Assault and battery. Hey, they're terms we often hear together, assault and battery. But are they one and the same? Well, not really, and that takes us to this week's case. Involves a real situation. Took place at a deposition. As we all know, a deposition is a procedure in a lawsuit in which one of the parties to the lawsuit has an opportunity to take sworn testimony of a witness on the other side and find out what they're going to say at trial. Well, in this particular deposition, we had two attorneys. One was Mr. Oakley, one was Mr. Bloom. Mr. Bloom got really upset at one point in time during the deposition. He rushed at Mr. Oakley, shaking his finger directly in his face and giving the impression that he might actually hit him. Well, the deposition went forward, but Mr. Oakley, after the deposition, brought suit against Mr. Bloom, contending that he, Mr. Bloom, engaged in assault. Now, what is assault? Assault is conduct by one person against another person in which the other person feels at risk for imminent physical injury. It isn't the actual striking of somebody, but it's placing them at risk. Good faith belief that they are at risk for imminent personal injury. Example being, simple example, one guy runs at another guy waving a baseball bat, looks like he's about to strike him. The guy who's on the receiving end of that says, hey, wait a second, you know, I'm kind of scared to death here because this guy could really beat the hell out of me and I am pretty upset. That's an example of assault. When the guy with a baseball bat actually hits the individual that he is moving towards, that becomes a battery when you have physical contact, either directly or through an instrumentality like a baseball bat. Okay. Well, in this instance, there was no physical contact, so it wasn't a battery, but it was contended to be an assault. Case went forward. It wound its way through the New York courts. That's where this case arose. Got up to a New York Court of Appeals, and up there, the court heard both arguments. On one side, Mr. Bloom argued, hey, you know, sure, maybe I didn't act as good as I should have acted, but, you know, in this instance, I was pretty upset, and yeah, I did basically shake my finger at Mr. Oakley very close to his face, but I didn't intend to hurt him or cause him any real harm. Mr. Oakley on the other side says, I don't care what he is saying at the time this took place. I didn't know if he was actually going to hit me and if I was going to be subjected to some other kind of an actual battery. Well, court looked at this and they said, given the context of this case, while this certainly was not appropriate conduct on behalf of Mr. Bloom, it was unprofessional, uncivil conduct, nonetheless, it did not arise to the level of an actual assault because the court, based upon the totality of the circumstances, said they did not think that Mr. Oakley really was placed in imminent threat of physical injury and therefore did not suffer an assault. So the case was dismissed. And that was the end of it. Okay. So what do we learn from this case? What we learn from this case is an important thing. Assault and battery are two different things. Here we saw a demonstration of that. And we bring you this case as we bring you cases every week so you understand how the law works. I'm David Allen.